committee. This is going to get to be a little bit technical, but I think that in Ms. Dolan's excellent testimony that she provided to this committee, there is really the key to understanding how we look at this situation. The problem is that the Bond Act, the law, does not say, that we have to build an initial operating segment. In fact, those words do not appear in the Bond Act. What the Bond Act says is that we have...
So just to clarify, you disagree with the court's ruling?
No, sir. I can explain the court's ruling. What the court said was that in the initial funding plan that the High-Speed Rail Authority provided in November of 2011, and Mr. Chairman, it was released just after I took over or was appointed by the governor. It was really in the can before that. That plan said that the first usable segment, and the usable segment is the key term here. That's what the Bond Act says we have to build. The authors of the Bond Act knew that nobody was going to be able to unwrap a 520-mile high-speed rail system like a train set under a Christmas tree in one day. They knew it was going to be built in segments. They said that those must be usable segments, and I believe Ms. Dolan quoted that in her memo. What happened was that the High-Speed Rail Authority defined its usable segment as the initial operating segment. And accordingly, the judge said, if that's your first usable segment, you have to show me all the money and you have to show me the environmental permits. And we did not have those. But what was not in front of the judge was the revised business plan that we put forward before the California legislature 4 months later in April of that year. And responding to a lot of public comment, what we did was we said the valley segment is in fact a usable segment.
The valley segment meaning the initial construction?
Correct. And it is a usable segment precisely because in response to public commentary, we're tying into Amtrak, we're tying into Ace Train, and we're doing these other things that would give it usability. And I would point out, Mr. Chairman, that in its approval of the first leg of that, the Surface Transportation Board used the term usable segment as a justification for why they were providing that approval. Our view is, and obviously the opponents of the project will come back and try to test it, our view is that if that is a usable segment, and we believe it is, that we will comply with the judge's ruling by showing that we have all of the funding for that, which we do, and all of the environmental permits, which we will. And I would just end on this point, Mr. Chairman, which as a former member of the California legislature, I think you'll appreciate. When our revised plan was put before the California legislature in the spring of 2012, some of your former colleagues asked Legislative Counsel, does the High-Speed Rail Authority revised business plan comply with Proposition 1A? And the answer that came back from Legislative Counsel in a very detailed written opinion was, yes, it does. That question has never been before Judge Kenney. He was dealing with the prior plan. So that is one of the reasons why, despite all of the press around this, we do not agree that in order to comply, in order to have access to the bonds, that we need to assemble $25 billion. We believe we have the funds in hand, and that what we need to do to comply is to show that and to finish the environmental process so that we have the environmental documents in hand, and that's eminently doable.
I guess the piece that I don't understand about this, I guess you would have two choices. Either ignore the court ruling altogether and hope that the Attorney General can go ahead and float the bonds.
No, sir.
Or, because you have a disagreement with the court is looking at the initial operating segment, and you're redefining the usable segment as the initial construction segment. You would have to actually go back to another court, to another judge, or to this very same judge and fight that case, would you not?
I would almost agree with that. First of all, there is no prospect that the Attorney General will try to sell the bonds until...
I didn't think there was, but...
Right. So I don't want to pretend that there is. What the judge said to us was, go back and redo your funding plan to show that it complies. My view is that we go back and we do exactly what the judge said. We are not, by any stretch of the imagination, Mr. Chairman, intending to ignore what the court said. What the court said was, before you can go forward, I need you to go back and redo this funding plan. In my view, that means updating the funding plan to be exactly what it was we presented to the California legislature that they determined was likely to comply with the Bond Act. There's been a lot of commentary about this, and I think most of it that has appeared in the press and the discussion has been wrong. But it means that we can comply with the judge's ruling, not ignore it, sir. We would not do that.
I'm ready to wrap up.
Yeah,
Do you have any more questions? Otherwise, I'll just keep going for a couple more minutes. If that's okay? Okay.
I'm finished.
Actually, I do want to finish this. I've got a couple more brief questions before we close, but do you want to go first?
No, I'm finished.
Ms. Napolitano.
Thank you, Mr. Chair, and this is an interesting extension, and I enjoy it. I've been privileged to be on Codels with Ms. Brown in Europe and have written on some of those really fast trains and spoken to the boards, some of the board members in regard to how they put the plan together. We did that, what, 3 years ago, something like that. The impressive thing about that was that their safety record, their ridership was exceedingly high, their cost was affordable, and if they can do it, why couldn't we, other than the fact that most of those countries own the land on which the transportation lines were geared to. So to me, we need to concentrate on the bigger picture, and that is the ability for us to be able to not necessarily compete, but be able to maintain the necessity of options for our ridership. You're right, in California, I can tell you when I was into the first phases of the building of the Freeway 105, which leads into Norwalk, where I live, it used to take me 20 minutes to the airport. It now takes me almost an hour. Same amount of distance. So we are congested, and there's more to come. How do we address the issues and begin to convince the general public and the government, especially my colleagues in Northern California, that this is going to be an effective way of being able to deal with part. It's not the whole answer. It is part of the answer. And we must be astute enough to understand that we need to invest it, and we need to convince our voters that this is where we need to go for the future of our generations. And as far as taking funds and putting them into other areas, I'm concerned about my project funding. I've covered that with you. But you can't commingle funds like water funds or transportation funds. Let's be real about that. So while we can talk big about how we need to be able to fund these other entities, we need to understand that that we are not able legally to commingle funds or to be able to transfer funds. But you know, there's an old the movie, I can't remember the name of it, but it said, "Build it and they will come." I have great expectations that it will be successful. And how we go about it is just having the faith that we can and that we will be able to not only find the funds, but find the partners to be able to do that. So with that, Ms. Corinne Brown, you want any further comments? No. Thank you. I yield back. Thank you, Mr. Chair.
Thank you, Ms. Napolitano. I just wanted to follow up on the last discussion we had. So if you disagree with the court's decision or you have a difference of opinion on what that usable segment is, the court has defined that usable segment as the initial operating segment. If you're going to take your day in court, what is that timeline? When do you go back to court to clarify that?
First of all, Mr. Chairman, if I might clarify, I don't think it's a matter of us disagreeing with the court. What the court said was, what I have in front of me, the preliminary plan from the high-speed rail, you guys defined usable segment as the initial operating segment. If that's your definition, then you have to meet these other tests.
But Prop 1A defines it as well.
The words initial operating segment do not appear in Proposition 1A. It only talks about a usable segment.
Correct.
So my predecessors on the High-Speed Rail Authority Board, as they were looking at their business plan and finance plan, which I inherited in November of 2011, they they equated initial operating segment with a usable segment. And the judge said, okay, I'm going to take you guys at your word, and if that's the case, you needed to check these boxes. It's not a matter that we're saying the judge was wrong. What we're saying is that after that plan that he had in front of him, we presented an updated plan to the legislature that did not equate usable segment with the initial operating segment. It equated usable segment with the first valley construction as enhanced by connections to existing rail. We think then that meets the same standard that the judge was talking about, and that is what the legislature voted on, and that is what the legislature's lawyers looked at and said met the provisions of Prop 1A.
Either case, either you have to comply with the court decision, it's a $20 billion hole to have an electrified track that goes around Palmdale and to San Fernando Valley. That's electrified. That will be high speed. Hopefully it's not running a subsidy because that's what Prop 1A says.
You won't be allowed to.
So either you have to come up with that $20 billion and comply with the court, or you have to comply with Prop 1A, which says, if you're redefining that usable segment still says it cannot operate with the subsidy and it cannot operate outside of high speed. So you're saying that this construction segment will not be high speed. It will not be electrified. It will just be a second Amtrak, which I know Mr. McCarthy, if he were still here, has huge issues with having two Amtraks that stop in his district and you get on a bus on both of them to go over the Tehachapi's. So if it's not high speed, because it's not electrified, and it's running a subsidy, how does that initial construction segment comply with Prop 1A?
Mr. Chairman, I think maybe one of the most useful things I could do is to provide the committee with the opinion of California Legislative Council. In a 21-page single-spaced opinion, they went through and looked at our revised business plan. They were asked by two of your former colleagues in the California legislature, does this comply? They concluded it did. That informed the vote of the California legislature to appropriate the bond monies to move forward. And they went through an extensive legal analysis about why it did. I could try to go through that here, but I fear, sir, that we'd really get down into the weeds. But what I would say to you is, I think for this committee's purposes today, what you're interested in doing is making sure that the federal taxpayers are protected and that we have the ability to pay them back. I can't tell you, Chairman Denham, when we might have access to the bond funds. People who oppose the project will continue to bring litigation. But I can tell you that we believe that our revised business plan is in harmony with Proposition 1A. We believe that that can be established. And we think that we have other backstop mechanisms. So from the standpoint of federal taxpayers, we don't think that there's a question. As a member of the delegation from the Central Valley, I think you are also concerned about other aspects of this. Is this just going to be stuck in the Central Valley? Are your citizens going to actually be able to get to Los Angeles and San Francisco? And there, Mr. Chairman, I think we are hoping to come back to you very soon and say, if we look at the bond money and we look at the cap and trade dollars, we really believe, I think, I want to be able to confirm this, but our vision is that we can get all the way to Palmdale, connect to the Metrolink, and that triggers private sector investment. And Mr. Chairman, I would look forward to working with you to work through that, because if that is the case, I think that's going to address many of the questions that you've had about this project. And that is what we're aiming to do right now.
And I don't know that you and I have ever had this conversation, but I think you're absolutely correct. That is my concern. My concern is that we build another Amtrak that stops in Bakersfield, and the rest of the nation looks at California and says, you just spent $6 billion. And it's decades, if ever, that this thing ever gets accomplished. Now, I know you and I are both, you're moving forward, and that's your job. It's my job is looking over the federal tax dollars that we're actually spending money properly, and that we're not putting my voters, my state, at risk of losing highway dollars, aviation dollars, or education dollars. And so I look forward to this continued dialogue. I look forward to you getting me that information that proves that this operating segment either complies with the court decision or that this construction segment complies with Prop 1A. But I certainly think that FRA, I know that FRA has the ability. The question is whether they have the will to make a determination at a certain point, whether that's April 1 when there's $180 million due, or whether that's later in this budget year if the $250 million of cap and trade money becomes unconstitutional, or the legislature just votes it down. At a certain point, FRA may be forced to make a determination that they withhold funds. I have a better solution, and I'm prepared to introduce a bill that will require FRA to suspend all payments until California High-Speed Rail Authority has the matching funds available and is not hindered in coming forward with that and spending that money. So I will be introducing this bill before we leave on our district work period next week, and I'm happy to share the language with that to you after this hearing. Ms. Brown, do you have any closing remarks?